Minnesota federal judge denies Minnesota's plea to stop DHS's Operation Metro Surge. This is Law and Society. Welcome. Please subscribe. And we're going to talk about this ruling by a Minnesota federal judge, which has denied Minnesota's ask for a restraining order, which this court has taken as a preliminary injunction, which means that the court has said that DHS can continue their Operation Metro Surge because Minnesota has not met its burden of showing that it would succeed on the merits of the claim that they're trying to make, which is that the federal government has run afoul of anti-commandeering and the 10th Amendment by carrying out these roving patrols, these murders. And what I think, my overarching impression of the legal analysis that this judge has done is that she has been extremely conservative in applying the anti-commandeering laws, because the case as presented by Minnesota used Supreme Court precedent, none of which fit very precisely enough within the anti-commandeering doctrine and the 10th Amendment principles. And this judge has decided to err on the side of caution when it comes to the harm that plaintiffs are enduring versus the harm that the government claims that it is enduring, which is its immigration operations and national security reasons, and it feels that the government's claim must be given a certain level of weight, and the judge makes this finding, and I want to read this first, and then if you are not interested in going over the full legal analysis, you may drop off. But I want you to know that this judge acknowledges something while ruling that the preliminary injunction is not appropriate. So she says, plaintiffs have made a strong showing that Operation Metro Surge has had and will likely continue to have profound and even heartbreaking consequences on the state of Minnesota, the Twin Cities, and Minnesotans. Since Operation Metro Surge began, there have been multiple shootings of Minnesota residents by federal immigration enforcement agents. Additionally, there is evidence that ICE and CBP agents have engaged in racial profiling, excessive use of force, and other harmful actions. So there is harm there. The court is acknowledging it. And defendants do nothing to refute the negative impacts described by plaintiffs in almost every arena of daily life, from the expenditure of vast resources in police overtime to a plummeting students' attendance in schools, from a delay in responding to emergency calls to extreme hardship for small businesses. It would be difficult to overstate the effect of this operation is having on citizens of Minnesota, and the court must acknowledge that reality here. But then it goes on to say that the Eighth Circuit has recently reiterated that the entry of an injunction barring the federal government from enforcing federal law imposes significant harm on the federal government. And defendants have presented evidence that the entry of the injunction requested by plaintiffs would harm the federal government's efforts to enforce federal immigration laws. And the court says that it finds that the balance of harms doesn't decisively favor an injunction. Despite the shots, but she doesn't record the deaths of Alex Preddy or Renee Good, but she talks about the how the anti-commandeering principles are not specific enough for her to grant the injunction that would stop all of that harm that is being incurred on the state of Minnesota and on Minnesotans include the deprivation of life, let alone due process of law, and liberty by detention and abduction and disappearing. And the court looks at this and says, even when these rights are being impinged, the federal government's right of applying federal law takes the higher ground, which is really erring on the side of caution in such a way as this ruling wasn't even necessary. Like this, it almost is an insult. So what I will do now is I'll read you the legal reasoning for it. So I'll read you excerpts from the case really quickly, from the ruling, and if there are parts where I interject, it'll be to further explain that part. Thank you for being here, by the way. Please remember to subscribe and like if you're leaving at this point, and please return with, share with people, and return when I come up with more episodes, and they are already scheduled. So remember, if you want to join, there's no obligation to join as members, but if you do join as a member of this channel, then you get to watch the videos as I upload them, as opposed to the preset timings. And that's the only perk that I have to offer. Nobody needs to do it. It's just because some people are more active on my channel than not. So, going with the legal reasoning. The federal government can run afoul of anti-commandeering principles in several ways. 10th Amendment is violated when the federal government attempts to compel states to enact or administer a federal regulatory program. That hasn't happened here. The federal government also cannot command states' officers or those of their political subdivisions to administer or enforce a federal regulatory program because federal laws conscripting state officials violate state sovereignty and are thus not in accord with the Constitution. And I don't think the federal government has done that either. And that's what this court is going to be saying later on. Even when the federal government purports to offer the state governments a choice, it may cross the line distinguishing encouragement from coercion. Plaintiffs contend that Operation Metro Surge violates anti-commandeering doctrine and infringes on plaintiffs' police powers by requiring plaintiffs to expend significant state and local resources to address the harmful effects of the surge on their respective jurisdictions, ultimately diverting resource away from other matters of state and local priority. So that's a harm that the state is showing. Plaintiffs assert that defendants are carrying out Operation Metro Surge in unlawful ways to coerce plaintiffs through force into abandoning policies they have a 10th Amendment right to adopt. Pointing to defendants' own statements, plaintiffs argue that Operation Metro Surge is not a legitimate exercise of federal law enforcement power, but instead a campaign to force plaintiffs to yield and abandon their sanctuary policies. Insofar as plaintiffs' 10th Amendment claims do not challenge the constitutionality of any federal statutes, defendants' challenged conduct does not fit neatly into the clearly defined prohibitions on the exercise of federal authority. Plaintiffs ask the court to extend existing precedent to a new context where its application is less direct, namely to an unprecedented deployment of armed federal immigration officers to aggressively enforce immigration statutes. None of the statutes on which they rely have even come close. While the novelty of plaintiffs' claims does not necessarily preclude their ultimate success on the merits, it weighs against the propriety of preliminary injunctive relief. Plaintiffs argue that defendants are carrying out Operation Metro Surge in brazenly lawless ways, specifically to coerce plaintiffs into modifying or repealing their sanctuary laws and ordinances and otherwise cooperate with the executive, thereby commandeering plaintiffs' legislative processes. Plaintiffs certainly have put forth evidence to support this theory, including Attorney General Bondi's letter to Governor Walz, where states as much as much, and other statements by defendant and other executive branch officials, and plaintiff's theory finds additional support in more recent statements by executive officials. For example, Borders Czar Tom Homan on January 29 said the withdrawal of law enforcement resources here is dependent on cooperation by state and local officials with the administration's immigration priorities, not in the law and order priority that the local and state have. That's what's at stake here. The local and state authorities are saying that the operations objectives and the operations practice is going and pushing and pressuring against the state's policing powers and the right and the power that is that is on the other side of the balance is the federal government's immigration priorities. So, and the court essentially says that the immigration priorities take precedent, despite the loss of life, liberty, and due process of law. Several courts have already determined that the federal government cannot coerce sanctuary jurisdiction into changing their laws or carrying out executive branch's immigration priorities by threatening to withhold appropriated funds. Several executive branch officials emphasized that Operation Metro Surge was a necessary response to allegations of widespread fraud in Minnesota against government programs. Defendants have introduced evidence that the operation was also launched to increase arrests of non-citizens with criminal convictions in Minnesota and the Twin Cities, an effort they claim has been hindered by plaintiffs' refusal to assist federal immigration enforcement efforts. Plaintiffs don't have to follow federal immigration efforts, by the way. Plaintiff sanctuary policies require a greater presence of federal agents to achieve the federal government's immigration enforcement objectives that in a jurisdiction that actively assists ICE. Because there is evidence supporting both sides' arguments as to motivation and the relative merits of each side's competing positions are unclear, the court is reluctant to find the likelihood of success factor weighs sufficiently in favor of granting a preliminary injunction. The Supreme Court's anti-commandeering case law involves situations where the federal government's infringement on state sovereignty is not a question of fact, but a legal on-off switch. There's either a clearly identifiable congressional or regulatory command that violates state sovereignty, or there is not. But even when it is clear that the coercion is, the case law does not describe a way by which the court could draw the line between constitutionally permissible pressure and impermissible compulsion. The absence of doctrinal instruction on how to draw the necessary line, compounded by the challenges in drawing such a line in the context of Operation Metro Surge, means that issuing the requested injunctive relief could overstep the judicial role, as the Eighth Circuit very recently cautioned. Federal courts do not exercise general oversight of the executive branch. So you get to see that the court is essentially trying to be as non-existent as possible in this case. And I think there was more than enough evidence presented by plaintiffs to show that the harm that is being caused to Minnesota and Minnesotans' life, liberty, and due process are all, and their right to property, when their personal effects are being taken away and not returned, when they're being detained in cruel and unusual circumstances, none of that weighs as much as the federal government's right to enforce immigration laws. That's what this court is saying. And I'm not sure that the court's ruling is correct on the facts presented to this court. But that's it. Thank you for listening. Let's keep a watch, and I will talk to you soon.